Thank you very much for the kind introduction, and I'm very pleased to be here in Oman for the first time. I've done a lot of work in the region. When I was in-house counsel, we did a lot of work in Saudi Arabia, so I was in Saudi fairly often, but I've never been to Oman, strangely enough. So it's a real pleasure to be here. Yesterday was not a very good day for me, and I'm referring to the World Cup. I know it was a great day for Saudi when they beat Argentina the other day, but unfortunately my home country, which is Canada, didn't do quite so well yesterday. They lost 1-0 to Belgium. I thought maybe there would be a chance of another miracle, but unfortunately not. The other, I'm also German by background. My parents were German. And of course, that's the other team I could then root for, but unfortunately they lost to Japan. So it was not a very good day for me, but I hope that today is going to be a much better day being with all of you here today. So it's a real pleasure. So I'm here to talk a little bit about mediation. And it's something that very recently, actually, at the Arbitration Center, and Dr. Massa sponsored CEDAR, and you see CEDAR up there. CEDAR is a dispute resolution institution in England, and it was really at the heart of the development of mediation in the UK. So CEDAR does a lot of training for mediators. And they just ran a training course here in Oman. I think it was a very successful course. And we are really looking to bring mediation into this region because this is a region where mediation is just natural in the culture. And many people have told me about the Majlis system and how that works. And so it's not something foreign. And I think that's the important thing for all of you to also understand, that mediation is something that I think is innate in people generally worldwide. Because rather than having conflict, just naturally we try to discuss and negotiate with each other. So mediation is a form of negotiation with a neutral. I mean, it's a facilitated type of negotiation, but it is nothing more than really negotiation, finding a way to resolve an issue through discussion with each other. Rather than the alternative, of course, is the court system that has been built up in all countries, which is a different type of structure, because there you've got a judge or judges who make a determination. They decide something, and the parties then have to comply with that. Sometimes reluctantly, and so you have to force them to comply sometimes. So that just demonstrates that it's not the best way of resolving a dispute. Sometimes that's the only way to resolve a dispute because parties just won't agree, and so somebody has to decide. So it's necessary, but in the alternative, there are other methods. And so that's really what I'd like to talk to you a little bit about today is mediation. And maybe I've got too much information here, but hopefully it's something that will just assist you in understanding the process. And I want to talk a little bit about the process and how it works, what the role of the mediator is, and really how the parties can utilize mediation to try to find a solution. So the important thing for you to understand is that the mediator doesn't make a determination. The mediator is not a judge. The mediator is somebody who has learned how to help people to communicate with each other and to maybe explore with them the real reasons for the dispute, why the dispute arose, and what the parties really need in order to find a resolution. In the court system, the lawyers, they put together arguments for their clients, whether it's for the claimant or for the defendant. The lawyers try to put the best position forward for their clients. But in mediation, it's not so much about who's right or wrong. That's for a decision maker to decide. The mediator actually tries to find out from the parties what is it that they really want to try to achieve through the discussions, through the negotiations. And so that's what we'll talk about a little, the process for the mediator to be able to do that. So just starting here, this is really looking at sort of the dispute resolution spectrum, as we call it. So on the left-hand side, you've got binding processes. These are processes where somebody makes a decision. And that's, whether it's in court, whether it's arbitration, whether it's adjudication. In many places, and I'm not sure about Oman, but expert determination can also be binding. And sometimes it's voluntary, but sometimes it's binding. But it's where there's an imposed decision. The parties are forced to do something. Then you've got the non-binding types of dispute resolution. And amongst those is mediation, because the mediator doesn't make a determination. So if we look at, what is mediation? And you can look at it in different ways. It's helping people to have a difficult conversation, because what happens when people come into conflict is that they can't communicate with each other anymore. Just think of situations that you've been in where you've had an argument with somebody. It could be your brother, sister, it could be your husband, wife, or whatever. You have an argument, and then it's difficult for you to start talking again. And in a family situation, usually you do again because it's a family, right? But in business relationships, sometimes people just won't deal with each other anymore, right? They've had a bad argument. They feel emotional, and this is at the heart of a lot of conflict, is emotion, of course. Anger, sadness, regret, all of these feelings. So the mediator is a neutral. So the mediator is not somebody that's involved in the dispute. And so being a neutral person, they can come in and they can listen to both parties, and they can help those parties to start communicating with each other again. So helping them to have difficult conversations is important. It's important to understand that mediation is an informal process. So it's not part of the court system necessarily. In some places it is also part of the system, but it's not something generally that people are forced to do. Mediation is voluntary. Okay? So the parties come to mediation because they want to be there. The other aspect of mediation that's important is that it's confidential generally. The discussions with the mediator are confidential discussions. The mediator can't reveal what's said to them in private unless they've got permission from the party to reveal what was said to them. So it's a confidential process, very important, the confidential process. And generally, in most jurisdictions, it's what we call without prejudice as well, which means whatever is said in the mediation can't be used in any court proceedings later. And that's important too, so that people can open up and speak with each other. It's very important. And so it's confidential and without prejudice. And that helps the process. And it helps the mediator to explore with the parties. And we'll speak a little bit more about exploration. And it's a way of parties trying to resolve matters, as I said, with a neutral third party. So when is mediation most effective? When does it work? When does it normally work? where parties have a relationship. So just think of a business situation. Two parties have entered into the business relationship with each other for mutual benefit. Both of them believe that they're going to benefit from it. They often have a business relationship for many years. And then something happens, and they have a falling out. They have a disagreement. They interpret perhaps the contract differently. And there is then a dispute that arises. So where there's a relationship, there's an incentive for people to try to find a way to fix it because they're motivated to continue working together. Sometimes they can't continue to work together. Sometimes they have to separate. But it's much better to try to find a negotiated way to separate than getting a court to decide that for you. So again, even where they're separating, it's better to find a resolution through something like mediation. So where there's a relationship, there's a good opportunity to try to find a solution through mediation. Often, and I'm not sure in Oman whether that's the case, but if you go to court, it's a public matter. Is it the same in Oman? So the court records are public records, so people understand what's happening. People who are curious, or even the press, the newspapers, they can report on this kind of thing. So often people don't want that, particularly where they're business relationships. They don't want everybody to understand what is going on in the business relationship. So this is a good way to do it in confidence. I mean, that's why I talked about confidentiality. It's an important element of it, confidentiality. So where something has to be maintained in a confidential atmosphere, mediation is a good tool for it. The costs of litigation are often quite high, not so much the court fees, but you've got to pay the lawyers. And in business, and I know this myself from being in business for many years, if you have a dispute, it's a distraction for the business, because the business then has to work with the lawyers. You have to take people out of the business to go to court and to prepare for court. And so there's a lot of distraction and cost to litigation, and it takes a long time. And then usually in litigation, you can then appeal it to a higher court. And so sometimes it takes many years before you actually have a determination. Whereas in mediation, it's something that can be done fairly quickly, and the parties can get together quickly and make a determination of what they want to do, and then move on. So it's not something that is there for many years. It's something that can be done rather quickly. And the important one is the last point, I think. Again, the parties retain control because they decide whether they want to settle on certain terms or not. It's not a third party, a judge or an arbitral tribunal, that's making a determination for you. So that's a very powerful tool, because you'd rather resolve something yourself than be told. I think everybody would agree they don't want to be told what to do. They'd rather make a decision themselves, and that's really what mediation allows you to do. So maybe just a few other points here. Mediation allows you to come up with solutions that a court can't come up with. For example, in a business relationship, if you've got the potential for another project, you can talk about it. If I resolve this dispute with you and make perhaps a payment to you, I also would like to be involved in your next project. So is that something we can agree? So you can agree things that a court can't agree on that, but you can agree to that in the negotiation. So that's something that is also important. The other thing that I find in mediation, you ask the people who have authority to make a decision to come to the mediation. So you've got the decision makers there. So for a business, you've got the senior management that is involved in the mediation. They might not be the people that were involved in the project. The problem is often with the people who were involved in the project, because they've had a falling out with each other. They can't talk with each other anymore. Each of them is saying, I'm right, you're wrong. But the senior people, they've got a different perspective. They're looking at it with respect to the relationship, the overall relationship. And they can usually come to a determination with each other much more easily than perhaps the project people could. So it's important that you have the senior people there, and if the senior people are there, you will often get an agreement. We already talked about speed. I think the last point is very important. I worked internationally in many different jurisdictions, and culture to me is one of the main reasons that often disputes arise, because people don't understand each other. It's the problem of communication. I understand one thing when I say it, you understand something different, particularly if we come from, we have different languages we use, but we try to use one common language. Let's say it's English, but our understanding is very different, perhaps. Even amongst people, of course, that are English speaking, they have a difference in interpretation often. So contracts, when they're actually structured, mean different things to different people, and particularly culturally, they mean different things to different people. In some places I've been, a contract is really just the start of a negotiation. So you enter into a contract, but they then feel, well, you continue to negotiate even afterwards. Other people would say, no, I've signed a contract with you. That's what it says. This is what it means. So you have a dispute. And so culture is important. But the reason I say culture in mediation is something that can be accommodated is because it's not a formal setting. If you go to a court in a particular country, you've got to comply with the rules of that court. You have no choice. With mediation, you can work with the mediator to structure the process in a way that you feel comfortable with. So whether maybe there are interpreters there, maybe sometimes there's what we call co-mediation. There are even two mediators, so maybe one from one culture, one from another culture. It allows you to be flexible, and so the whole process is flexible. Another benefit for mediation. So just quickly, how does mediation work? So we've already said it's a confidential process. And even the settlement can be maintained as confidential. It doesn't have to be revealed. It's not like a court judgment that is revealed. And so that is something that is important as part of the process. We said already it's without prejudice, so you can't use whatever is discussed in the mediation in any future litigation. It's important because you also get to choose the mediator. So generally, the parties choose the mediator, the lawyers for the parties, they choose the mediator. So it's not like a judge who you have no choice. I mean, this is a judge you're going to get, right? The mediator, you can choose the mediator, and you can decide what the qualities are that you want. What languages should the mediator speak? What background should they have? Should they be a lawyer? Or maybe it's an accounting issue. Maybe you need an accountant. So you decide what the characteristics are that you want from the mediator. So that's very helpful because it already helps you to build trust with that individual because it's somebody that you've chosen. But both parties have to choose. And as I said before, it should be a neutral person, somebody not involved in the dispute. And you maintain control. That's the important thing. You maintain control and you decide whether you're going to settle or not. The other thing is the mediator tries to move the people from the past, which is the problem, to starting to think about the future. So whether it's continuing the relationship and starting to talk about how you continue that relationship and what are the things that have to perhaps change or what are perhaps what are the future business prospects that can be discussed with the parties, and you move them from the past, the emotion, to the future, and that's what you're trying to do. even if they decide that they're going to separate, you're still talking about the future. How do we separate from each other, right? And what are the terms for separating from each other? Again, much more effective than going to court, where that decision isn't up to you. It's going to be decided by the judge, and it may not be something that you're very happy with when you get the judgment. And as we already emphasized, the mediator is a facilitator. The mediator helps the parties to come to a resolution. The mediator does not make a decision or a determination. So this is important for, I think, the lawyers in the room to understand. How many here are lawyers? Who's a lawyer? Right, okay, so quite a few of you. The lawyers play a very important role in mediation. This isn't a process where lawyers are not involved. They are involved, and it's very important for the lawyers to be involved, but they have to be involved in a different way, not the way they would be involved in a court setting where they're just putting the parties' positions before the court and making an argument on behalf of the party. Here, the lawyers are trying to work with the mediator to help find a solution. I mean, the lawyers understand their party's positions very well, but they don't really understand the other party's position other than what the other lawyer has said. So it's a matter of actually working with their party and with the mediator to try to find a solution. So if the lawyers understand that process, then they can be very effective in the mediation. And most important, they can help prepare their client for the discussion that's going to take place in the mediation. So before the mediation starts, they're very important in helping to put together the negotiation strategy and the objectives. What is it that we're really trying to achieve, and how are we going to achieve that in the mediation? They're also very important in working with the mediator to put the process together. So they will have discussions with the mediator before the mediation starts about things like who is going to attend the mediation? Who are the people from my party that are going? Are they the people that have the authority to settle? Are there other people that should also be at the mediation? This is the other thing that's important with mediation is it's not only the parties, but if the parties feel that there are other interested individuals that should be at the mediation, then they could also be invited to the discussion. If you've got a dispute, for example, where there's also insurance involved, well, maybe the insurer who actually have to pay money should also come to the mediation, so they understand, right? Maybe in a construction project, there's the contractor and the subcontractor. So those are the parties that are arguing with each other. But maybe there are other suppliers, for example, that maybe they were late in supplying the subcontractor, and so the subcontractor couldn't do what it had to do. So maybe those people should also be part of the discussion because maybe they have to pay something, and they're also interested in future relationships. So you get everybody around a table, and that's really all it is, getting everybody around the table to discuss how to resolve the problem, because it's everybody's problem. And that's really the way to look at mediation. It's problem solving. We've got a problem, right? It's like the climate. We've got a problem. Well, everybody tries to get together at the COPs to try to figure it out. Well, we haven't been very successful so far, but that's the idea. You get everybody together and you come up with a solution rather than having somebody tell you what the solution is. So this is where the legal representatives play an important role. So just a few other things that the legal representatives do. And lawyers often, if they don't understand mediation, really don't advise their clients to mediate because they don't understand it themselves, or maybe they think that the court process is one that is more effective because, of course, that's the way they've been trained. That's only natural. That's proper for lawyers to think that way. But they should also be looking at this as a way to help their clients find a faster and probably a less expensive solution. And so that's where, lawyers really have to change their mindset a bit as well once they understand what mediation can do for their clients. So let's just talk about mediation rules a little bit, because there are different institutions around the region here in particular, and most of them have mediation rules now that can be utilized. So the mediation rules are just a framework for the mediation. It's not like court rules. They don't set out all the steps in the process. Rather, they're just a framework. And usually they will include things like confidentiality and without prejudice. So they are an additional layer of protection for the mediation itself. And so here in the region, the SCCA has mediation rules, as well as arbitration rules. I believe the Oman Arbitration Center also has mediation rules. So there are different ones. The ICC, also well known, has mediation rules. CEDAR has rules as well. So when you're writing a contract, you can actually write a mediation provision into the contract. So that's a good way to actually get mediation into the overall dispute resolution of the contract. You can write that into the clause. Sometimes the other party, when you try to discuss this, they don't understand mediation, so they don't agree. But it's usually the clause where you will put something like arbitration or the courts into the clause. You can also try to put mediation in there. And if mediation is in there, then the parties will first have to try to mediate before they can go to court or to arbitration. So it's effective if in a business to try to put that into your contracts. Otherwise, if you don't have it in your contract, then of course once the dispute arises, parties are always free to try to decide to mediate. The problem is once a dispute arises, people aren't really talking with each other anymore. They're then turning it over to the lawyers, and then often the opportunity for mediation is lost because the lawyers might not push mediation. The institutions also help with selection of mediators, because they often have panels of mediators, so the institutions are very useful for that. And they can also help with the administration of the mediation. So you can have institutional mediations, or you can have ad hoc meaning that the parties just decide who the mediator is going to be, and the mediator puts the process together without rules. It works either way. So appointing the mediators, as I said, jointly selected by the parties. So the parties decide who the mediator is going to be. If they can't decide, then if they're under institutional rules, then usually the rules will have a manner of appointing the mediator. The institution usually then will appoint the mediator for the parties if they can't decide on who the mediator is going to be. The important thing to remember, though, is even if you go into mediation, the parties are free to leave mediation at any time. It's not like the court process, where once you get into it, you have to stay there because it's something that you're required to do. Mediation, if parties decide this isn't working, I'm not happy with it, they can just stop the mediation whenever they like. I mean, that's the freedom that the parties have in mediation. So we already talked a little bit about the qualities of the mediator. This is something, again, the parties can decide what qualities the mediator has. Each of these institutions usually has a panel that you can choose from. So just what are some of the practical steps in mediation? How does it starts? Well, it starts with either there being a clause in the contract or the parties making an offer to each other that they should mediate. So it starts with that. And then there's an agreement between the parties to mediate. Sometimes there's the support of an institution if you've agreed to an institution to help administer the mediation. Then there's the choice of the mediators. And usually what happens is once the mediator is appointed, the mediator will take up contact with usually the lawyers for the parties. And there'll be an initial management conference. So the mediator will have a discussion with the lawyers about the process. Who is coming? Where is the mediation going to take place? Is it going to be virtual? Today, many mediations over the last 2 years, of course, with the pandemic, were virtual because you couldn't meet with people. So you did it over a virtual network, could be Zoom or Teams or whatever you use. And it's also effective. It actually works. I've done many mediations now virtually, and for international mediations where the parties are from different places, actually it's very convenient because you can then have the mediation at a time that's convenient to the parties. Sometimes it's night for one and morning for the other, but it still works. And you can have basically the same structure in a virtual mediation. But what a virtual mediation doesn't allow you to do, it's as if I were coming to you virtually now, I'd be up on the screen, you could still be hearing me, but you don't build the same rapport with people. And in mediation, rapport is very important. The way people behave with each other, when you smile, you go and have a coffee, I mean, all of these things help, right? Because it helps build a relationship between the mediator and the parties, and slowly between the parties as well. Because when you go and have a tea or a coffee or some food with each other, that's one of the best ways for people to start communicating again, right? So you can't do that virtually. I mean, you can have a virtual coffee, but it doesn't quite work the same way. Okay, so once it's decided, you know, where and how and who is coming to the mediation, then there will be a date that's decided for the mediation. And as I said, the lawyers should be preparing their clients for this. What are our objectives? What are we going there to do? What are we trying to achieve? How are we going to achieve that? This is something lawyers are talking to their clients about and prepared. So when they come to the mediation, they have an understanding why they're there. Like, what are we trying to achieve here? So normally the mediation opens with a plenary session, which means everybody gets together in the room together. The mediator will have a large room. There'll be a table, whether it's square or circular, whatever it is, and everybody will sit around the table. Sometimes people are sitting there who haven't talked with each other for some time. Sometimes they don't want to even be in the same room with each other, right? That is often the case. There's a lot of emotion. So the mediator has to be prepared to deal with a lot of emotion. Sometimes anger, sometimes sadness, sometimes people are crying. It happens because, you know, all of a sudden everything comes back. Why they had this dispute, all of those things come back to them, right? So it's a difficult situation. Sometimes people don't want to be in the same room, and you have to talk to them about why and try to convince them to be in the same room. But being in the same room together is the start of the healing process, if I could call it that, because they're all in there for a reason. So all of a sudden they're all there together to talk about the problem. And usually people want to talk about the problem because that's what's been inside them. People always say, I want my day in court. Why do they want their day in court? Because they want to be able to express all the feelings, the anger, whatever it is that they have against the other party. So this is actually like having your day in court. In fact, it's better than having your day in court because you really do get to express your feelings. So in the plenary session, in the opening session, the mediator will first explain their role, that this is confidential, without prejudice, that, you know, this is voluntary, you can leave whenever you feel you don't want to take part in the process anymore. And there's no settlement until we agree a settlement and people actually sign a settlement. So you're not bound by anything that's said here. You can say whatever you like, you can make any proposal you like, You're not bound by it. And so usually the parties will have an opportunity then to explain what happened. Why are they there, right? What is this about? And that's when they get to have an opportunity to try to express this. The mediator will try to ensure that they're not shouting at each other, that they each have an opportunity to speak, that they should listen to what the other party is saying. And hearing is very important because often we don't really understand the position of the other party. So this allows the parties to start talking to each other again in a controlled atmosphere, right? And that's very powerful. Then the lawyers will often have something to say too, because they'll talk about the positions again and the legal position of their party. And of course, both of them will say that my party has a stronger position. And I mean, that's just normal. But this is what happens in the plenary sessions. It's just a session with everybody together. The other thing the mediator tries to do at the end of the session is to put together an agenda. What are the topics that we want to talk about? What are the important things that we all want to talk about here today? So you have really an agenda of items that people want to talk about and they think are important for them. And so at the end of it, there's a bit of a roadmap. Where are we going today? And at that point, the mediator can decide if the discussions are going quite well with the parties and they're actually starting to speak to each other and we have this agenda, maybe we can start going through this agenda together. Often at that point, it's still too difficult to do that because there's still too much of a positional view in the parties, right and wrong. So what the mediator then does is that he or she will break the parties into separate rooms. Everybody has their own room where they can feel comfortable. And the mediator will then start going from one room to the other room. And we'll get into the process a little bit further. But that's in essence what the mediator will do, and we'll speak in confidence then with each party and start to explore with the parties what it is they really need out of this. Then hopefully at the end of it, there will be an agreement between the parties on how they resolve this problem that they've got. And that leads then to a settlement. And mediation, and it depends on where you are in the world, but it can be 50% successful, 60%, 70%, in some places 80% successful. But if you think about it, even if 50% are successful, that's already an incentive to do it because it then will create a situation where you don't have to go to court. And so it's something that does work. It really does. And then the mediator and the lawyers, they will then work on the settlement agreement. Usually the lawyers will actually draft the settlement agreement because there are a lot of other legal matters that have to be included in the settlement agreement. So typically the lawyers will draft that and the mediator will be there to assist. So just looking at the phases of the mediation again, we start off with the preparation before the mediation starts. We have the opening session where everybody gets together. Then we have the private meetings where the mediator explores the dispute with the parties and what they're looking and what they're needing. And then there's bargaining, because bargaining is, of course, part of all of this, right? It's the negotiation part of it, where the parties are coming up with potential solutions to resolve it, and the mediator's helping them with those solutions. Maybe if it's still in private rooms, the mediator is communicating from one room to the other and saying, this is what is being offered by party A, and party B says, well, we don't really like this, but I would suggest we would do this, and then the mediator goes from party B back to party A. So it's a process that takes a while to reach a conclusion. Okay? So maybe I'm just going to stop there for a minute because that's a lot of information. Do you have any questions? I'm sure you must have some questions about, just the process itself and how the process works. Yes, my student.
Yes. So I think one of the things that I found really interesting is that when you have two parties and clearly one party is more powerful than the other, how do you as a mediator manage your own biases and prejudice?
Right. Well, this is, the power imbalance, and we find that, of course, in the litigation process where one party perhaps, is financially more able to bring the litigation and the other party is less able to defend it. You have the power imbalance, maybe with the lawyers that are hired or with the amount of money that can be spent in preparation for litigation. In mediation, it's actually a little bit different because the parties are coming together really on a much more equal playing field because it's a discussion that's taking place. It of course is important how much preparation takes place, but it's not that important, who your lawyer is or not, because it's not, the mediator's not a decision maker. So it levels actually the field between parties who are more powerful or less powerful, because they're not convincing the mediator of anything. And once they understand that, they have to try to convince the other party. And so the discussion has to be more about how do we solve this problem, rather than, I've got, a more powerful position than you do. So that it's a good point, but the mediator is going to treat the parties equally and spend as much time with each party as is necessary. And it doesn't really matter, if one party is more influential than the other party. That's not the point. The point is, well, we still got this problem. It doesn't matter, who you are. How do we solve this problem, right? Yes?
You mentioned that the mediator will talk to the lawyers.
Yes.
Of both sides.
Yes.
And from your experience, do you find that the presence of the lawyers, is it helpful in the process of mediation? Because some would feel that maybe lawyers are taking adversarial position.
Yes, right.
And therefore may have also personal interest.
Yes.
With regard to their fees that the
yes,
litigation,
that's a very
proceed to the court.
Yeah, that's a very good point that you make. So obviously everybody in the room has different interests, right? Even the lawyer and the client may have a different interest. I mean, the lawyer is representing the client and obviously has to have the client's interest as well as part of their duties. But it's often the case that maybe there is also the financial aspect between the client and the lawyer that is part of the discussion that is taking place. Lawyers, like I said earlier, if they understand the process, are very helpful because they can also discuss with their client the alternatives. I mean, if we go to court, maybe we have a 60% chance of succeeding, right? But there's a 40% chance that we won't succeed. So maybe the offer that's being made by the other party is a good offer, because if we look at the risks of going to litigation, take the money now, you might be in a better position. So the lawyer can have that conversation with their client, and it's very helpful to in that respect. So I think lawyers play an important role. Sometimes, and this is a mediator has control of the process. So the mediator can suggest, although this is sometimes not the best way to do it, but they could suggest maybe I have a private discussion with the client, not with the lawyer there. All right, maybe to discover exactly that point. That, well, I have trouble paying my lawyer, right? I mean, this may be part of the discussion. I can only pay the lawyer X amount. And so maybe you can have a discussion with the lawyer, but if I settle this today and I've got to pay the other party this money, I don't have enough money really to pay maybe the lawyer's fees. So that could be part of the overall settlement, is also what is he going to or she going to pay the lawyer. So it's a very flexible process where the mediator can have discussions with all the different interested parties, and often that's hidden. You don't know what that is until you start speaking to people, right? Because that doesn't come out automatically. So that's an important, a very important point. Anybody else with respect to process? Yes.
As you mentioned, that the mediation is not a judicial proceeding, more than like it's facilitating between the two parties. But what if one of the parties need to provide a witness in the mediation proceeding? Can the mediator allow one of the parties to provide a witness?
So witnesses are really part of the judicial process, because here you're not actually trying to convince the mediator of anything. So the witnesses aren't really necessary to the process, because the mediator isn't making a decision and listening to the position of the parties through witnesses. But there are situations where maybe an expert or experts are providing information in the mediation, not so much for the mediator, but actually for the other parties, right? Because at the end of the day, you have to convince the other party to agree to a settlement, and so you're trying to convince them. So maybe in that context, within a party, there might be 2 or 3 people that were involved in the project, so maybe people that would be witnesses in litigation. They might have an opportunity then to speak about what they were involved in, or the factual aspects of the matter, just so that the other party understands what their position is and what happened, right? But not to convince the mediator, because the mediator isn't going to decide anything.
What about the duration time for this process?
For the mediation process? Yeah, so that's really, that's up to the parties and the mediator to discuss. I mean, if you want to have a mediation, you can have it tomorrow if everybody agrees. I mean, it could be very quick to set up the mediation itself. I mean, it's going to be usually longer than that, and then the mediation, once it starts, you can resolve it sometimes in a day or 2 days. Sometimes it takes more than that. It depends on how complex it is and maybe how many other people are involved in it. But traditionally, mediations wouldn't take more than 1 or 2 days. I mean, that's typically how much time it takes.
Is it true that if it's not settled within 2 days, then it's not going to settle?
No. I've had a mediation just recently. It took 6 months because the parties were in different places, and they had to get more information for the other party, and it took them some time to get the information. So there's no strict time period for it. I mean, it's as long as people want to continue speaking. Because the important thing is, people always have to look, well, what's the alternative, okay? If I don't resolve this, then what's the alternative going to be? Usually the alternative is some type of court or arbitration process. So if that has already started, the court process usually has time limitations, right? And so parties then are bound by a time frame, because they have to meet then the court process, because they're trying to resolve this before they go to court. So in that sense, there is a time limitation. But otherwise, I mean, parties can decide. And sometimes it doesn't resolve, during the mediation. But maybe a month later, parties are now getting ready to go to court, and they decide, again, maybe that's not the best thing. I'm really concerned now whether I'm going to be successful or not in court. So then they go back to the mediator again, and maybe there are some points that still have to be discussed and resolved. So it's a process you can go back to again too. Even if it doesn't work the first time, you can go back to it again.
Just have a question about, in your experience, because you said you worked in many different jurisdictions, do you think that different business cultures have a lot of an impact on whether or not mediation will be successful? Because I feel like in some business cultures, parties are already oppositional from the
Yes.
moment they start negotiating the
Right,
contract before
right.
they even enter the project.
Yes, I agree with you that it depends on both the business culture and also the regional culture as to whether people will mediate or not. I mean, that's an important element. There are businesses, and I would say, just my own experience with oil and gas, for example, oil and gas majors, they don't, or at least traditionally, wouldn't mediate. They would either negotiate and find a solution, which generally is where they resolved it through senior management negotiations, or they would arbitrate. That's true, or sometimes go to court, but generally in the international context, arbitrate. Because they saw mediation as being sort of a soft tool. If they couldn't resolve it, then they would actually spend money and go to arbitration. But that's, I think, changing. And I think it's changing because of, well, first of all, what we've gone through with the pandemic, I think affected a lot of businesses and taught them to be more collaborative, because I think everybody thought there'd be a lot of litigation coming out of the pandemic, but in fact, it hasn't happened because companies found a way to resolve a lot of those, because they're all in the same position, right? So they found a way to resolve those disputes through being pragmatic and through negotiation with each other. So I think there's more of a cultural mindset in companies now to try to be more collaborative. But I think also because of the financial situation and the financial uncertainty, there's a big risk if you're going to go through a litigation process that might take several years. Maybe the counterparty isn't even going to be there in several years. So you're better to take, maybe 50% of what you feel you're owed today and walk away with that rather than risk being able to collect it later on. So I think there are a number of factors at play right now. That's why I think people are much more, and companies are much more interested in maybe looking at how mediation might be useful. Yes?
So you said in the beginning that the mediation process is not binding. However, I assume the settlement agreement would be legally binding.
Yes.
Would the settlement agreement hold in court or arbitration, and would the without prejudice in proceedings affect that?
No. Well, so the without prejudice is with respect to the information that's developed in the mediation. So what is a settlement agreement? Well, a settlement agreement is a contractual agreement between the parties. So first of all, it can be enforced as a contractual agreement. But if in the context of arbitration, you've got mediation, often the arbitrators will agree that there be a consent award, so it can actually be enforced then as an award. And particularly internationally, that's important. It depends on the jurisdiction, but some jurisdictions under their law allow the settlement agreement then to be enforced in court as a court judgment. And now there's this convention called the Singapore Convention, the Singapore Mediation Convention. And it came into force in 2019. There are 55 signatory countries to it. And in fact, Saudi Arabia and Qatar are both signatories and have actually ratified the treaty already as well. And the UAE just announced earlier this year that they're going to sign the Singapore Convention as well. And maybe Oman is also interested in looking at the Singapore Convention. But the reason that's important is it is with respect to enforcement of cross-border mediated settlements. So not for domestic ones, but if the parties are from different jurisdictions that are signatory to the convention. It's like the New York Convention for arbitration. It allows you to enforce the mediated settlement in the other country, as if it were then, so the courts have to enforce it. So that's a big step forward for mediation because it makes enforcement of cross-border settlements.
Thanks. In your experience, are there any circumstances or situations you've faced where you found as a practitioner that maybe it would be ill-advised to seek mediation? Red flags, perhaps. Perhaps disputants don't agree on the facts. What kind of sort of red flags you as a practitioner would be clear to you if you see them that maybe it's a waste of time to go ahead with mediation, if any?
Yeah. No, I think there probably are some situations, and if I look at my time as in-house counsel, where we would think maybe mediation wasn't the best process to utilize. And that is where there is a decision that you want to be able to use as a precedent in future, maybe relationships. It could be something to do with IP, for example, where you do want a court to actually make a determination that you can then utilize in other negotiations. So there are situations where you do need or feel you need a court determination. But I would say in most commercial disputes where you want to try to find a resolution, then you will opt for mediation. So we actually had an internal policy where we would, well, first of all, try to write mediation into our disputes clauses where the other party agreed, of course, but there were situations where the other party wouldn't agree to it because they didn't really understand it, particularly in international contracts where maybe in a state where there just wasn't a tradition of mediation, they wouldn't agree to it. But typically we would try to do that, or if we didn't have it in our agreement, then during the process of resolving a dispute, and even sitting down with our outside lawyers at the beginning, we would see, at what might be an appropriate time for us to try to negotiate this, but if we couldn't negotiate it, to maybe suggest mediation to the other party. So, that's the nice thing about mediation, is that it's something that the parties have to decide. So you're not forced into it, certainly.
What about the financial fee of mediation?
Right. Well, that's also a good question. So if you've got an institution that's involved, just like in arbitration, the institution will typically charge something for the administration. So there'll be an administration fee. And then there's, of course, the mediator's fee as well. And again, that's either the institution sets the limits of the fee, so there's maybe an hourly rate that the institution will set, or there's a negotiation with the mediator as to their fee, so the parties will negotiate the fee.
So is it considered less than arbitration?
Yes, well, first of all, it's not as lengthy a process as arbitration, so you're paying the mediator for a much shorter period of time than an arbitrator. And I would say mediators' fees are maybe comparable to, maybe less than arbitrators' fees. I mean, it depends on the mediator. And usually they charge a daily fee rather than an hourly fee. So, basically if you're taking the mediator for 2 or 3 days, you know how much you're going to pay. Yes.
So you're an arbitrator and mediator.
Yes.
So from your experience, you had a case, but for arbitration, but you have seen that this case doesn't have to go through arbitration. From my experience in the arbitration center, I see people tend to go to arbitration instead of mediation. Have you ever convinced the parties to go through mediation instead of arbitration? Because you don't have to go for arbitration. Maybe the amount is way too low for arbitration.
Yeah.
Or it's not that complicated case.
Right.
Have you ever convinced or tried to suggest
parties to go through mediation instead of arbitration?
Yeah, so that's a very good question. First of all, usually institutions like your arbitration institution, they will have a discussion with the parties at the outset because they see what's being filed and, have they considered mediation. In some institutions that I'm familiar with, they actually require parties to mediate, so they'll actually send them to mediation first. But the arbitrators, I mean, they I think today will take a more pragmatic view as well, and they might very well just suggest that there be a mediation. And that's something the arbitrators could do. Again, there's a bit of a conflict of interest maybe because the arbitrators are appointed and they obviously would be interested financially in the arbitration going ahead. But if you're going to be fair to the parties, and what's happening nowadays, and a lot of institutions like the ICC is looking at this right now, for example, that there be a mediation in parallel with the arbitration. So different people, not the same people doing it, but you appoint the tribunal, you also appoint the mediator. Maybe the mediator tries to resolve it. Maybe there are parts that can be resolved by the parties, but maybe there's a legal issue, a determination of law, that the parties, they just can't agree on this. And then maybe that has to go to the arbitrators for a determination of the law. And then maybe the damages come back to the mediation where the parties then discuss damages. So both run in parallel, and it's actually a very sensible way of doing it in parallel like that. Okay, I didn't want to keep you too long today, but there's another element of this that I wanted to just go through with you, which I think is really important. And I don't know at the end of this, do you want to distribute the slides to everybody? I'm quite happy for you to do it. So, because there's a lot of content here that we're just not going to have time to go through. But I'm happy if you'd like to distribute it. So we've talked about a lot of this and the opening and the private sessions. But I'd like to talk to you a little bit about exploration, because this is something that the mediator does with the parties, is really to explore what this dispute is all about. What we see, and this is the iceberg diagram, is a good example of what we normally see in a dispute. Because what we always see are the positions of the parties. And that's really what the lawyers are putting together. It's what is being claimed, what is being demanded, potentially what are the solutions that the parties are looking for, and most important, what are their rights? I mean, this is what the law is all about. What's my right? I'm right, you're wrong. And this is what we see here, and that's the discussion that usually takes place in litigation. That's all you see. What the mediator does is tries to, so that's the information that's known to parties. The mediator tries to find the information that's unknown to the parties at the outset. And that's what really we call the interests of the parties. What are they really interested in? So that's when you get into some of these other contexts. Hopes and fears, needs and concerns. So you can think of in a business situation, where somebody has brought a claim for a certain amount of money against another party, and the other party hasn't complied with whatever the contract required them to do. But why is it that they haven't complied? There's usually some reason for it, because people typically intentionally won't refuse to comply with the contractual requirement. Well, there's something underlying it. So maybe there's a cash flow issue that the business has. Maybe they can't pay right now, but they can pay in a month from now. But they haven't revealed that to the other party because it's a weakness that they don't want to discuss. Well, they may discuss that with the mediator in private and tell, well, I wanted to pay, but I can't pay right now. But if we can structure the payments, then maybe I can resolve this with the other party. Feelings and emotions, we've already talked about how important that is, financial pressures. Sometimes it's a personal issue. I mean, maybe the one party has problems, private problems that are causing some of the issues. But of course, they'll never talk about that with the other party. But the mediator can at least find out about it and then see how that can be dealt with in the resolution. Reputation is often important. So often in projects, particularly large projects where there are projects teams from the different companies involved, the people who are there daily working on the project, they start having an issue. But they don't want to tell their boss about it because they feel that's going to affect them and their reputation in the company, for example. So the problem escalates and it becomes worse. And they're telling their boss, well, it's not us, it's the other people. They're at fault. It's not us. They're causing the delay, for example. And so it's often a situation where just the individual or the individuals have a reputational issue. So when you come to the mediation, these are the types of things that you can discuss because all of a sudden you're talking about it in a different context. And maybe it's another, as I told you before, management, more senior management that are at the mediation. And they then recognize, well, our people have been telling us it's not our fault, it's their fault, but maybe some of the blame is our blame too. And so we have to try to resolve this because if we go to court and the judge is going to hear from both sides and maybe they won't believe our people, they'll believe the other people. So it's a situation where reputation and risk are an important element. And then just personal and commercial drivers. So really that's again going back to relationships and convincing people that they have a better opportunity if they resolve this to continue to have a business relationship with each other. It's very difficult after you go through a bitter litigation with another commercial party for you to continue to have a relationship because you've just gone through a very difficult experience. And why would I want to do business with you again? Because maybe I'll have to go through this again. I don't want to do that. So it's difficult. But if you can resolve it in a settlement, then often you can continue to have a relationship. Okay, so I think, let me just go through this quickly and see what else we might want to talk about. So in the bargaining phase, so when you're actually discussing how do we resolve this, this is the stage where you have a better understanding for why this dispute arose and what the parties actually are looking to achieve. So now you're working with the parties to see if you can achieve a resolution that both of them will feel comfortable with. So you explore different solutions to finding a resolution. And you start to build on it. So, one party will say something about what they would like to see happen. Maybe that's not acceptable to the other party, but the other party will come back with what they think is acceptable. And so slowly between the two, you start building a solution that they both find will be acceptable. So it's a compromise, usually, that you have to come to, but both of them are working on that compromise with you as a neutral. And why it works here and maybe not in direct negotiation is because the parties feel the neutral is somebody that has credibility and then they can trust. So that's what you build up with the parties as a mediator. You build up trust. And that's an important factor because usually in direct discussions they don't trust each other. So they're not going to get anywhere. And that's where you get to a situation where nothing can actually be agreed. But with the mediator, that's something that allows, the process allows to happen. So you can often find very pragmatic solutions that the parties haven't even thought about previously. But all of a sudden, with the help of a mediator, and maybe with the mediator making suggestions as well, you can come up with a solution which nobody had even anticipated. So here are just some tips when you're bargaining in any situation, actually, whether it's in mediation or not. You really have to understand what is it the other side needs. So that's always important in any negotiation. It's not just what do I want, but go into the negotiation thinking about what does the other side need and what do I think they need to get out of this? Because what do I have to do to try to get them what do I have to do to get to meet their needs as well, and to incorporate that into it? Because otherwise, it's like everything. You won't have an agreement if you just want to get whatever you want and don't have an understanding. And the mediator actually helps with that, because the mediator can explore with the other side what it is that they need. And with the permission of that party, they can then explain to the other party, well, they really need more time to pay. That's what they need. So how do we do that? Can we give them more time to pay? How do we structure that? So that's something the mediator helps with. It's interesting, people never want to make the first offer when they're negotiating, because they think that if they do that, they'll be at a disadvantage, because they're not sure what does the other party really want. But often by making the first offer, you actually then start a conversation around that position. Maybe it's totally unacceptable to the other side, but there's already something on the table then, and then the discussion has to take place around that. And even if they come back with a different offer, they're still going to come back with an offer that is in that range, because otherwise it's totally it's not rational, right? So often if you start by making the first offer, you then anchor, as we say, the discussions that take place after that. It's really important, and I think all of you understand when you're negotiating too, that you have to have some explanation for the position that you're taking. So, and if you don't, the mediator is going to ask you, why are you taking this position? Why are you making an offer which you know is going to be an insult to the other party? Is that going to get you where you want to go today? Is that how you're going to achieve your objective? Is that really the best way to do it? And so the mediator forces the party to really look at why they're making a particular offer to the other party and provide support for that position. So maybe they have a reason for making an insult offer, and that reason can then be explained by the mediator to the other side too. So it's important for the mediator to be able to explain why an offer is being made, and for a party to then think about why they're making a particular offer. Sometimes you can also use language that you've heard in the mediation, that the other party has said something that you can actually utilize then in building up the settlement offer. And what happens just typically in a mediation is you go back and forth, and you're going to go back and forth several times before you actually get to a range that's going to be acceptable for the parties to accept. So usually parties start at extreme ends from each other, particularly if we're talking about financial matters, but slowly they move towards a range where it's going to be acceptable. The other point is, often people start by thinking it's only financial. But at the end, it's not simply financial, because as we've already talked about, there are relationships to explore, there are future projects to explore. Sometimes it's an apology that somebody's looking for. The apology is so important for them to hear, that the other party is actually perhaps sorry about what happened. And that then allows them to reconnect and allows the relationship to build again, right? So, often we think, well, this apology isn't important. I mean, what's that got to do with a business context, right? Well, even in business, sometimes, because we're all human beings, we're all people, an apology really works. And sometimes that's what opens the door to further negotiation. So maybe if I just... So maybe this is an important point too. Just in any negotiation that you have, there are different barriers to actually getting to an agreement. In our case here, to a settlement. It could be because you have different factual perceptions of what happened, or with respect to a contract, what a contract might mean. And then we also have legal differences. We interpret the law differently, and so there are legal issues that prevent us from reaching an agreement. So differing perceptions is an important element or a barrier to finding a settlement. Sometimes there are other pressures that prevent a party from settling. For example, financial, not being able to pay something because they simply don't have the cash flow to do it. Or there are personal animosities between the parties that then hinder them speaking to each other again. So the mediator has to try to break that down. Failures in communication, we've already talked about that. That's a very common reason for there being a barrier to people agreeing something. So that's something the mediator has to then try to deal with. And sometimes one party just feels delaying something, particularly payment, is to their advantage. Particularly if they're the more powerful party and there's a weaker party, and they know that they're going to have to try to settle for something far less than what they're really owed. So again, you've got to convince that other party, the one that wants to delay, that really delay is not an advantage to them. And so that's another barrier to settlement. And if you don't have the right parties at the mediation, as I said, you really need the parties who are have the authority to settle there, and also the other parties that are peripheral, perhaps to the dispute, like an insurer, for example, that they are also there for the discussion, because without them, you probably won't reach a resolution. And sometimes there's more information that has to be developed, and maybe the parties have to go off and get that information and then come back with that information before there can be a resolution. So finally, we get to settlement, and that's hopefully where we end up at the end of the mediation. And if there's no settlement, then there's still at least a lot of information that the parties have learned about the other side's position. And as I said, often it will result in a settlement sometime later because the parties now have a better understanding for their positions. And so as they get closer to the court hearing, all of a sudden all of the risks become evident again, and they then decide that they will want to resolve it. And so they might come back to the mediator at that point in time as well. And so we talked about the Singapore Convention. That's an important advancement in enforcing mediated settlements. So hopefully Oman will also be amongst the countries signing that. All right, well with that, we're finished. Thank you very much, and you've been very attentive. Thank you. Are there any final questions anybody has? Yes?
What's the purpose of
The choosing the mediator?
Yeah, the process.
Oh, the process. So, yeah, usually if it's institutional, if there's an institution involved, the institution will have a list of mediators that the parties can choose from. Or maybe the lawyers are familiar with some mediators that they then discuss, the lawyers. Yeah. So they may suggest then a mediator, but typically the mediator is chosen by the parties. If they can't choose the mediator, then often the institution will appoint the mediator.
So, this, as you mentioned, the institution as ICC and the other one, they are international institution or they are in the region?
They're also regional. So the Saudi Center also has mediators, and they also have mediation rules, the Saudi Center. And I believe the Oman Center also has mediation rules. I'm not sure if you have a panel of mediators yet, but I think they're working on it. Not yet, but they're working on it, I think, because they're training mediators.
We have mediation rules.
You've got rules, but I don't think you have a panel of mediators yet. Do you have you have a panel? Okay, and
We
then
have panel and we have
right. Okay.
it's in the website of Oman Arbitration Center.
Yeah. And then I know that DIAC in the UAE in Dubai, they are currently also working on mediation rules, and I expect that they'll have a mediation panel as well. And in Abu Dhabi at the ADGM, they have a mediation panel there as well. So in the region, there are panels that you can choose mediators from.
Hi, sorry, could you expand a little bit on the enforcement of the settlement agreement? So they're contracts, and they're not directly enforceable, right? You still need to get the judgment that there was a breach of a contract if one party fails to fulfill it?
That
Or are they directly enforceable?
So, yes. So one means of enforcement is by dealing with them as contracts that have been breached. That's one way. In some jurisdictions, and I'm not aware of the situation in Oman, but in some jurisdictions, the courts will enforce the settlement agreement as if it were a court judgment. In international agreements now, the Singapore Convention will allow you to enforce a cross-border mediated settlement in the signatory country as if it were then also a judgment of the court. So the courts will be required to enforce the settlement agreement. So you don't have to go through the whole argument of breach of contract. Yes. So it's going to become easier to enforce these agreements. Yes.
What if the mediator suspects a lie?
What is, sorry?
What if the mediator suspects a lie?
What if the mediator?
Suspects a lie, someone lies.
Oh, somebody lies. Oh, okay, right. Well, I mean, you as a mediator, I mean, you don't know if somebody's lying to you or not. I mean, it's not, so again, you're not the judge. So the judge has to decide often, you know, is a witness honest, is a witness not honest? How do I weigh the evidence that I received from the parties? The mediator is not really testing whether it's a lie or not a lie. The mediator has to, you know, accept what people are saying to them. That doesn't mean that it's necessarily true, because they may then discuss with the other party, and the other party will say, no, that's not what happened. I mean, this is what really happened. But the point is, you're not trying to find out who's right or wrong. You're trying to help them find a solution. So even if one party is being dishonest, if the parties agree to the solution, then they've agreed to it. They have to accept it, and they have to sign the settlement agreement. And so I think you have to get beyond that. I mean, that might be what happens at the outset of the mediation, and people will give you a different version of the facts. But at the end of it, they still have to try to find a solution. So it's not quite the same process as in a court.
Which process do you think is more sufficient, arbitration or mediation to settle the dispute?
what,
What process is more?
uh, well, there are two different processes. So if you want somebody else to decide for you, then you've got to go to arbitration, because the arbitrator will decide. Mediation, the mediator is not deciding anything. The mediator is going to help to find a solution. So I think it's probably a preferable process if the parties can agree to something themselves than having somebody tell them what to do. So, but it depends on what you want. I mean, if you want to find a solution yourself, or do you want somebody to tell you what to do? That's really the difference. So very different processes. Yes?
My question is, what are the rules that govern the...
Great. Much better. Thank you.
What are the rules that govern the mediating sessions?
So, there are different frameworks for the mediation. There might be a mediation law in the country, so there's a framework in the mediation law. Not all countries have mediation law, but many countries do. Then there's also the institution. There might be a mediation institution that's involved. They will have mediation rules. So the rules also then govern the mediation. And then the mediator and the parties will also discuss the process and agree a process between themselves. So there are different frameworks for the mediation to take place within. But mediations are much less formal than the court process, and you don't have strict rules like you do in the court process. It's much more flexible, and so much of it is agreed between the parties and the mediator.
Do the parties usually set a time frame for themselves to get the dispute resolved?
So you can look at also at the contract, because usually when you have a mediation clause in a contract, it will set a time frame, because otherwise a party can delay and delay and delay. So they'll usually say, the mediation will be tried for 30 days or 45 days, whatever it is. And then if that fails, then the party can go on to arbitration or to litigation.
And
So
the parties can agree to extend the period?
yes, yeah. Because it's contractual, right? So the parties can always agree that. Sometimes the mediation rules have a time frame in them as well, but there's always a provision that the parties can agree to extend it. Okay, anyone else? No? One more.
Question regarding the agreement.
Yes.
Final agreement between both parties.
Yes.
Who is responsible to write the agreement? The lawyers from both sides or the mediator?
Yeah. The mediator usually doesn't want to actually draft the agreement because, as you say, they're usually lawyers on both sides, and they also have a better understanding for some of the other issues. For example, maybe there are some tax considerations, and there may be other legal implications. The mediator isn't there to be the lawyer. The mediator is there just to facilitate the agreement. So the mediator usually wants the lawyers to draft the agreement. The mediator is there if the lawyers have any questions about, I didn't quite understand what was agreed, so the mediator can help explain what was agreed, but the agreement itself should be drafted by the lawyers.
I do have a question. Is there any agreement or something you need to sign before the session?
Yes, so that's a good question. If there's an institution involved, they will often deal with the agreement between the parties and the mediator, but there should be an agreement between the parties and the mediator, because it's also a contractual relationship in a sense, right? The mediator is providing a service, the parties are then paying for a service, and so there should be some agreement, particularly with respect to payment, because otherwise the mediator has no way to enforce their own fees, right? Typically the institution, when they're involved, they'll collect the money ahead of time anyway. But if it's ad hoc, just myself and the parties, then I want to have an agreement with them. So, yes. And also confidentiality is usually included in that agreement, so the parties have to maintain confidentiality.
So after the both lawyers from both sides, after they agreed on the final structure and this is our agreement and this is confirmed, who will announce about this agreement at the final stage? The mediator or the lawyer?
So, I mean, if there's an agreement in principle between the parties, the mediator will usually just write down the heads of agreement that the mediator will then give to the lawyers to draft the settlement agreement from. That's usually what happens. And sometimes, as part of the settlement, if it's particularly something that is important to either the parties or maybe it's something that is publicly important, then they will also agree that there be some kind of press release. Not necessarily, because we said this is a confidential process, but sometimes they want to make a press statement, so they agree a press release together, and that part then isn't confidential.
Also, it can be in the institution themselves. They can be a lawyer in that company, so they will take care for the agreement.
Yes, could also be the lawyer from the company, of course. Yeah. They could also help draft the agreement. Yeah, it doesn't have to be an outside lawyer. And sometimes institutions have sort of what they call a template agreement that can be used and then just filled in. That's possible too. Yeah. Yes.
If there's a dispute that arises between two parties from different countries or regions, can the mediation, and they decide to solve it with mediation, can it be as efficient as solving it in person, like through online? Can it
Yeah.
be as efficient as solving it in person, and does it differ than being in person?
Yes. So it can. I mean, a lot of mediations now have been virtual mediations, and it works very well for cross-country mediations because people don't have to travel. They don't have to have the expense of traveling. It's also much easier to arrange the timing because if people have to travel, you have to get agreement on when it's going to take place. But it's not quite the same because people aren't sitting together and you don't build the same relationship with people. But the process is very similar. Everything that we talked about, the opening session and the private sessions, they can still take place virtually. I mean, that's not a hindrance. And they're also quite successful. I find, I've done a lot now virtual mediations, and they work. They work. To me personally, because I've done, so many face-to-face mediations before the pandemic, I prefer to do face-to-face mediations. But virtual mediations have a place, definitely. Okay.
Okay. Thank you. So at the end of today's session, we'd like to thank Mr. Wolf for flying all the way from Dubai and making the time because he was there for the Dubai Arbitration Week. So thank you very much for this informative and insightful session.
Thank you.